Hi, class. All right. So last week we did criminal cases and the average procedure in the court system for a criminal case. This week we're going to do a civil case, the other major type within Canada's system. And while we go through the process for a civil lawsuit, there's going to be a few definitions we put in there that will, both the process itself and some definitions, will inform your discussion this week as well as your assignment. Okay, so this was also co-authored by a few currently practicing lawyers. All right. If there is a civil lawsuit, an injury has occurred. There are only a handful of categories through which people can sue each other civilly. One is contracts. This is typically something like someone is not performing their end of a contract that was signed. There are verbal contracts, and that can become part of a lawsuit as well. Usually it's signed, it's considered stronger if it's signed. Torts, which come to us from the common law, so that's the form of case law most common around the world because it originated in England, spread through the British Empire. It's a big part of Canada's system. And then torts, which are statutorily imposed. So the other type of law, statutory, that was defined in a law by the government in one document. Tort effectively means civil wrong. And it means that someone else's actions have somehow caused you harm. It can be a loss of time. That's where contracts come in. You were not given the outcome guaranteed or agreed upon with time and investment and labor. It can be physical injury and medical problems caused by someone else's actions, or it can be damage to your property and loss of resources because of someone else's actions. That's a civil wrong, and that's a tort. The most commonly sued tort is negligence. And that might be because if someone's not sure exactly how they can bring it to court, negligence is the most reliable. Something important happens with the injury. When it actually happens, a clock starts to run. Time is important when it comes to civil lawsuits. Okay? Typically you have 2 years from the date of the injury, whether it was physical, time-based, or property, resource-based. You have 2 years to begin a lawsuit. There are some exceptions to this. Usually it's 2 years. Certain things like environmental damage to a community can have much longer timelines because the courts have recognized the community may not realize it's being poisoned by, for example, a company dumping waste into some part of the bio table of the soil in the area or the waterways. Okay? Also, when it comes to medications having side effects that were never warned of, that can take more than 2 years. Mostly it's 2 years. First thing that has to happen is you actually file the lawsuit, but once you file the lawsuit, you have to very quickly serve the claim. And serving the claim is giving notice to the person you're suing or to the group that you're suing that they are going to be sued in a lawsuit, in a court case. And you have to personally serve the individual. There's only a few cases where you don't serve yourself. Usually you're going to serve yourself. And this is because the person, if you just mail it, they could claim they never got the mail, for example. So you serving it personally makes it very obvious that they can't say they never knew. Once you've served it, you do have to update the person if new motions in the court case, new charges or alleged wrongs are going to be added. The next step is this person you've served responding to the claim. Typically, the defendant, the person accused, has 20 days from the date of being served to respond. That doesn't sound long, and it isn't, but you can usually get the court to give you an extension to file your response on the matter. Really what they want to see is that you do exist, you're not ignoring your responsibilities, and you're taking the charges seriously. When someone gives a response, they will usually give the following: their defense, an affirmative defense, which means they have a legal defense for what they did. They might have a counterclaim against the person suing them. And they could have a cross-claim against another defendant trying to just blame some other person in a situation for what happened. And there's a third-party claim. Even if you find someone liable, you should put the responsibility on someone else. So again, that's sort of shifting the blame. And then any other defenses you will raise. All right, so a response to being served a lawsuit will be your defenses, a counterclaim if there is one, a cross-claim against another possible defendant, a third-party claim, which is another version of passing it on to someone else, and then any other defenses. Once this has been given, the plaintiff has the right to reply to everything the defendant has responded with. Okay? Pretty much exactly as it sounds. This is pretty much the beginning of the opportunity for the two sides to settle, because now they have seen a good breakdown of each other's arguments and probably want to just get this over with and done with rather than dragging it out and going to court. Next is discoveries. The two parties make a list of everything they require from and believe the other side to possess that's relevant to the case. There are exceptions to this, but broadly the other side is going to have to oblige and provide any documents they have, any evidence they have to the other side. Discoveries can take a very long time, but when they do, we can finally start to proceed with the court case, with the actual trial. In Toronto, Windsor, and Ottawa, there is mandatory mediation between the two parties. Elsewhere, it might not be mandatory. This was started as a pilot program a number of years ago to try and explore ways to lessen the burden on the court system. For reference, the civil court system in Ontario is severely backed up, and it can be difficult to even get a court case. All right, there's a huge log of undealt with court cases. So this pilot project came into effect in 3 test markets to try and speed things up. You must have some attempt at mediation. After some mediation, the next thing that you do is set the motion down for trial. This means that the two sides have concluded that there's nothing more to do between the two, and it is time to notify the court that they are ready to proceed with a date for a court case. Then you have a pre-trial conference. This will always be held with a judge who is not the judge that is going to be judging the case. A separate judge will do the pre-trial conference. The goal of the pre-trial conference is to try and clear up some of the issues, the more complicated issues that may arise when you go to court that you're not aware of going into it, and especially if they affect your argument in the case as the plaintiff or as the defendant. Additionally, whenever possible, they are going to encourage one side to settle. And in Ontario and Canada, this might relate to the huge overlog of cases. They're always going to encourage just settling without going to a case because there's already a backlog and you don't know when you're going to actually get your case, your trial date. Then you have trial preparation. This is incredibly time-consuming and costly for all parties involved. One of the reasons why it's recommended that you settle, because the judge will reveal all the things that an average person is not going to be able to prepare paperwork for, and that's why very few people represent themselves in court. Lawyers will represent you, and getting them to do all the work to prepare for the court date is expensive. Another reason that they encourage settling. Then you have the trial itself. The order for the trial is very similar to criminal law. The plaintiff gives an opening statement followed by the defendant. The plaintiff then makes their case, followed by the defendant making their case. You then have closing arguments by both sides. So witnesses might come into it, but it's brief opening argument from plaintiff and defendant, longer detailed argument from plaintiff and defendant, brief closing argument from plaintiff and defendant. Sometimes you have witnesses in between the arguments. Not always, though. Okay? After the arguments are given, the judge or the jury will give a finding of either someone is at fault and there's penalties, usually financial in nature. If you don't pay what you owe from a lawsuit, then it could become criminal and you could look at jail time, but usually it's financial. And that's pretty much it. You'll see it's a bit simpler than the criminal case, at least in terms of the fact that witnesses are not as much of a built-in process. You can have them as part of your argument, and then there's cross-examination and maybe re-examination. But it's mainly about giving arguments and evidence, and making sure that the evidence lines up to either prove the plaintiff correct, that they were wronged in the loss of time, loss of physical health, or loss of property, and that it's the plaintiff who was responsible and who should have known better and who was violating law in some way. Or the plaintiff, maybe with a counterclaim, may be proven correct, or the whole thing might be dismissed by a judge. That's why pretrial meetings are important, because you don't want your whole thing dismissed by a judge. Okay? Those are the basics for this. And next week we'll get into some of the issues that arise from this process. But for now, that we know the process, that's enough for discussion and for our assignment. All right. Have a good one, guys.